Welcome back. It's Monday and time for Law 101. I'm Rob Levine from Rob Levine Associates. So this week we're following up from last week. We started talking about the definition of negligence, and we said that was duty, breach, causation, and damages. So this week we're talking about breach. When that defendant, when somebody violates the reasonable prudent person standard, what do we have to look at to make sure we can prove they breached it? So the first thing is that they knew or should have known about the defect that caused your injury. So we refer to that as actual or constructive notice. So we talked about a motor vehicle last week. So a motor vehicle is easy. So if I'm driving a car, I have a duty to operate it reasonably. And obviously if I act outside that reasonable standard, I breach the standard of care. For everything that we do with a motor vehicle, driving forward, turning left, pulling away from a curb, coming out of a parking lot, backing up, there's a statute that controls how I operate my motor vehicle and that I have to operate it safely. So that's just going to be actual notice because I'm driving the car, I acted unreasonably, it's clear. So in another type of circumstances, when we look at real property, meaning someone's house, a store that you're visiting, there's a defect that occurs. So let's first talk about a home, and let's say that there's a banister loose in the hallway. And so there's two ways for me to find out about that loose banister. I either was told about it, so my tenant called me and said, hey, the banister going from the second floor to the third floor is really loose. It looks like it's going to fall off. So that's actual notice. I was told directly. I then have a responsibility to fix that. The next thing we'd look at is opportunity to cure. We'll get to that in a minute. If no one called me to tell me about the banister, then there's constructive notice. So remember I said knew or should have known. So should have known applies to constructive notice. So what does that mean? It means that if I own real property, I own a 3-family house, I have a duty to inspect it myself or have a manager who inspects the property for me. And if I'm not doing those things that the reasonable prudent person, meaning a reasonable prudent landlord, owner of a 3-family home, visiting the property to inspect it, and something happens, I should have known about it. So the question is then, did I have the opportunity to cure? So let's talk about a light in the hallway. So the light burns out. The hallway is completely dark and I fall down the stairs. If I say that, well, I left my apartment at 6 o'clock in the evening and the light was working, and I came home at 9 o'clock in the evening and it was out, and that's when I fell down the stairs, there's no way the landlord reasonably would have had time to know, knew or should have known about the light, because he's not going to inspect it every night. And even if someone called him in at 8 o'clock at night and said, hey, the light burned out in the hallway, the landlord wouldn't have had the opportunity to cure, not enough time to get over to the apartment to change the light bulb and replace it. Another example is snow. So first of all, if snow is falling, there's no duty to snow shovel. So if you fall during an active snowstorm, there's no negligence on behalf of the person who's responsible for clearing the snow. The duty doesn't begin until after the snow stops falling. So I have actual notice because if I look outside, I see that it's snowing. Therefore, I'm on notice. Now, the question is, opportunity to cure. What's a reasonable amount of time for the landlord to respond and safely clear the sidewalk and walkway and stairs so that I can get out? And that's going to become factual. There's no set time that I could tell you that the landlord should have responded. So, for example, if I'm the landlord and I live on the first floor, and my tenant lives on the second floor. And when I go to bed at night, I see that it's snowing. And I know my tenant goes to work every morning at 7 a.m. Well, it stopped snowing at 4 o'clock in the morning. I would argue, as the client's attorney, that, well, it would have been reasonable for the landlord who lives on the first floor and knows his tenant goes to work every morning at 7 to get up at 6 and look out the window. Did it stop snowing? Yep, it stopped snowing. He should have gone out, cleared the snow, and made the walkway and put down sand and salt. If he doesn't live there and he uses a plow company and maintenance company and it stopped snowing at 6 a.m. and the tenant was going to work at 7, the landlord is going to argue, well, I own 15 pieces of property. They went out as soon as it stopped snowing and they were going from one house to the next. Again, it's going to be factual and a jury's going to decide, do they believe the landlord operated reasonably? So, actual notice, constructive notice, and opportunity to cure, those are the things that we generally look at to determine if The defendant breached the standard of care, being a reasonable, prudent person. Thanks for joining us. We appreciate it. I know it's a lot of information, but it's information you need. We'll see you next Monday. Remember to like us, follow us, and share us on Facebook.